Good morning and welcome to the Supreme Court of the United Kingdom, where we are hearing the appeal in Evergreen Marine UK Limited and Nautical Challenge Limited. This is the second day of the hearing, and this morning we're going to hear the continuation of the submissions by Ms. Salvaratnam on behalf of the respondent. Salvaratnam.
Client's appeal on both questions 1 and 2 in order to show that the crossing rule applied to the encounter between the Alexandra 1 and the Eversmart. Question 2 is a freestanding basis for the dismissal of the Eversmart's appeal, and I propose to deal with it first. Our written case addresses question 2 in paragraphs 112 to 135. I'd like to begin by reminding the court of the important fact that there is no appeal against the trial judge's finding of fact that the Alexandra 1 was not on a course at all. And if I could invite your attention to the judgment of Mr. Justice Tier in Core Bundle 1 at page 207, paragraph 70. At 6 lines down in paragraph 70, the judge says this: however, I am very doubtful that Alexandra 1 was on a sufficiently constant heading to be on a course. The agreed schedule, and just pausing there, that's a reference to the schedule of movements which is in our core volume 1, shows that from C-26 until C-23, her course over the ground varied from 119 to 127 degrees, altering to starboard. From C-23 until C-12, her course over the ground varied from 127 to 81 degrees, altering to port. From C-12 until C-7, her course over the ground varied from 81 to 115 degrees, altering to starboard. And from C-7 until C-1.5, her course over the ground varied from 115 to 91 degrees, altering to port. During that same period, her heading also varied. From C-26 until C-14, her heading varied from 112 to 84 degrees, altering to port. From C-14 until C-8, her heading altered from 84 to 100 degrees, altering to starboard. And from C-8 until C-3, her heading altered from 100 to 90 degrees, altering to port. The variation of course made good and of heading was no doubt caused by the circumstance that Alexandra 1 was proceeding very slowly, about 1 to 2 knots over the ground. At such a slow speed, Alexandra 1 was not very manoeuvrable. Nevertheless, she made progress in a broadly east-south-easterly direction towards the entrance of the channel as she waited to embark the pilot. Was she on a sufficiently constant direction or heading to be on a course? I do not consider that she was. Her course made good varied between 81 and 127 degrees, and her heading varied between 84 and 112 degrees. It is difficult to describe that as a course, although her preliminary act describes her as being on an east-southeasterly course. I would describe her as maintaining a broadly east or east-southeasterly heading as she waited for the pilot vessel to approach. That required her to have some, but not very much, way on. I would describe Alexandra 1 as waiting for the pilot vessel to arrive rather than being on a course. And then he makes the observation, which you've seen already, that had a good lookout been kept on board the Eversmart from C-21 until collision, it would have been apparent that Alexandra 1 had moved less than a mile. It would or ought to have been obvious that she was waiting to embark a pilot. Now, there was an attempt to challenge that finding of fact in the Court of Appeal, by my learned friend, Mr. Jacob QC, who then appeared as lead counsel for the Eversmart. Paragraph 88 of the Court of Appeal's decision shows how that factual challenge was addressed. It's page 172 of our 4-volume 1. Paragraph 88 addresses what he calls question 2, which is in fact the factual question of whether the findings of Mr. Justice Tier in paragraph 70 could be challenged as constituting a basis for concluding there was no cause. And what Lord Justice Gross, delivering the judgment of the court, says in paragraph 88 is that notwithstanding Mr. Jacobs' submission summarised earlier, there is no sufficient basis for departing from the judge's conclusion of fact, the word fact being underlined, that Alexandra 1 was not on a sufficiently defined course for the crossing rules to apply. I am content to agree and adopt the judge's succinct description, namely, Alexandra 1 ... was ... waiting for the pilot vessel to arrive rather than being on a course. Now, those facts are now common ground and accepted by the appellants, and no permission to appeal has been given in relation to challenging those facts. So the issue of law, which we are now concerned with, raised by question 2, is whether it is a legal requirement for the giveaway ship to be on a course before the crossing rules can be engaged. In our submission, the legal authorities plainly support the fact that it is necessary for the putative giveaway ship to be on a course before the crossing rules can apply to the encounter. And I'd like to start by looking at the case of the Avance, a decision of Mr. Justice Brandon, as he then was, which is in the core volume of authorities, our core volume 2, at page 343. One can take the facts quite readily from the head note. We can see that the plaintiff's vessel, the Bambara, was on a voyage from Marseille to Dakar, partly laden, and she was outside the entrance of the harbour, waiting for a pilot to take her in. The defendant's vessel, the Avance, was on a voyage from Dakar to Sete, carrying a cargo, and she was proceeding out of the harbour to sea with a pilot on board. And the arrangement was that when the pilot had taken the Avance out of the harbour, he would leave her and then go by launch to the waiting Bambara in order to take her in. Now, the Avance in that encounter was the putative stand-on ship, and the Bambara was the putative give-way ship. If we now go to page 347 of the bundle, or 348, I think, in certain copies of the bundle, internal page of the report 147. If one goes to the left-hand column, the first complete paragraph, as will be apparent from the two accounts of how the collision occurred, which I've set out above, the basic issue between the parties is whether the Bambara was stationary and the Avance altered course to port, as the plaintiffs allege, or whether the Bambara was moving ahead and the Avance keeping a steady course outward, as the defendants allege. If we then go over the page, in the right-hand column, just over halfway down, I accept entirely the advice of the elder brethren on these matters and find that the Bambara moved forward about 1.5 to 2 cables during the period of about 3 to 3.5 minutes preceding the collision, and was still moving forward at about 1 knot when the collision occurred. Remember, the Bambara is the putative give-way ship in this encounter. If we then go to page 350 of the bundle, 351, I think, in certain copies, left-hand column, the last paragraph with a marginal sideline beside it, I've already found, as a result of my reading and analysis of the movements recorded in the engine movement book of the Bambara, and the evidence of Mr. Kante as to the interval between the order full ahead, just before the collision and collision, that the Bambara moved forward about 1.5 to 2 cables during the 3 to 3.5 minutes preceding the collision, and still had residual headway of about 1 knot when the collision occurred. If we could now go to the next page, 351, pick it up in the left-hand column, please, just over halfway down. For the reasons which I've given, I decide the main question in dispute in this case by finding that the collision was brought about by the Bambara moving ahead across the course line of the Avance and not by any alteration of course to port made by the latter vessel. It's now necessary to examine, on the findings of fact which I've made, the question of responsibility for the collision. In this connection, a question was raised as to whether the crossing rules in the collision regulations, and he identifies them, applied to the case, or whether the duties of the 2 ships concerned were governed solely by the principles of good seamanship, together with rules 27 and 29. On this point, I am clearly of the opinion that the crossing rules did not apply on the ground that the Bambara, she being the give-way ship, was not on any settled course at the time, nor was it possible for those on board the Avance to appreciate that she was. And the learned judge then refers to the Alcoa Rambler, which we have already looked at and which is in our bundle at page 311, and the cross-reference is to page 324 of the report, which is the passage that reiterates the necessity for the course, and the test was what was being done, open and notorious to seamen on the other ship. Now, my learned friend has submitted that this case is wrong in principle, but there is no evidence that it is treated as being an erroneous authority in any textbook that we have been able to find. And indeed, the statement of principle in the Avance is consistent with previous House of Lords authority. And I'd like to look at that next. It's the case of the Savina, which is to be found at page 831 of our authorities bundle. And just while you're turning that up, the Savina treats the Alcoa Rambler as authority for the proposition that in order for the crossing rules to apply, both vessels must be keeping a steady course involving a risk of collision. Now, if we go to the head note of the Savina, page 831, we can see that a collision occurred between the Forest Hill and the Savina in the roadstead of Ras Tanura. The Forest Hill was proceeding from an anchorage in the southern part of the roadstead to the sea on a northerly course. The Savina was proceeding from the south pier to an anchorage in the northern part of the roadstead on an easterly course. The stem and the starboard bow of the Savina struck the port side of the Forest Hill in way of her numbers 8 and 9 cargo tanks at an angle of about 75 degrees leaning forward on the Forest Hill. And at the time of the collision, the Forest Hill was doing about 8 knots through the water and Savina about 2 knots. Now, in this encounter, the Savina was the give-way vessel and was found to blame 40%. And the stand-on ship, the Forest Hill, was found to be 60% to blame. If we could go, please, to Lord Simon of Glaisdale's speech and pick it up at 836 of the bundle. We can see in the left-hand column that there were 4 questions of importance that were raised in the case. The first was the use to be made by an appellate court of its nautical assessors, which our assessors may find useful to look at in their own time. For our part, we are very grateful that the nautical assessors are able to assist this court, and we have certainly welcomed their ability to advise Mr Justice Tier and the Court of Appeal. The second question that Lord Simon considered was whether the crossing rules foreshadow a greater responsibility on a potential give-way ship than on the potential stand-on ship. And then questions 3 and 4 don't really impact. But it was the second question that led to the statements of principle that show that both vessels have to be keeping on a steady course involving a risk of collision for the crossing rules to be engaged. If we turn over to page 837, we can see about a third of the way down that the court discusses the holding of Mr Justice Brandon at first instance. Mr Justice Brandon held that a crossing situation involving rules 19 and 21 did not subsist until C-8. And his reasons for holding that the crossing rules didn't apply until then were firstly that she steadied on 350 degrees. When she steadied on until, the crossing rules did not apply until C-8 were, firstly, until she steadied on 350 degrees true, the Forest Hill was not on a definite course at all. See the Alcoa Rambler. And secondly, it was not till then that the ships were on crossing courses so as to involve a risk of collision. And then if we skip the citation of the rules, the Court of Appeal accepted Mr Justice Brandon's finding that these crossing rules applied at C-8 and not before. And accordingly, from C-8, the Forest Hill was the stand-on ship and the Savina was the give-way ship. So that it was thenceforward the duty of the Savina to keep out of the way of the Forest Hill and of the Forest Hill to keep her course and speed. If we then go to page 840, in the left-hand column, Lord Simon there deals with the argument about foreshadowing of the obligations imposed by a crossing situation. And he says, I cannot with all respect agree with counsel's submissions. The contention that a vessel with a red light on her starboard bow must always give way is, in my view, too wide a proposition in general and is inconsistent with the Alcoa Rambler. That case establishes, in my judgment, and we're now approaching the key point of the citing this decision, that case establishes, in my judgment, that for the duties under the crossing rules to apply, so as to impose on a vessel the duty to give way, both vessels, note both, must be keeping a steady course involving risk of collision, and the give-way vessel should be able to ascertain that the other vessel is on such a course. Before that moment, in my view, each vessel owes the other a general duty of careful navigation with good lookout on a basis of mutuality. This means, in practice, that each must watch the other carefully and ensure that the navigation of neither endangers the other. This accords with the advice given in the instant case by the elder brethren. And then he goes on to say, I respectfully agree with the Court of Appeal that there's no heavier duty of care on a potential give-way vessel than on a potential stand-on vessel, provided each vessel has, on a basis of mutuality, navigated in pursuance of her general duty of care. Any ensuing crossing situation can be negotiated without danger by each vessel fulfilling her respective navigational duty as defined by the crossing rules. So, clear statement there by Lord Simon that both vessels must be keeping a steady course and that there is mutuality of obligation. I'd like to turn next to the Orduna, which is another House of Lords case that supports the same proposition. That's at page 412 of our authorities bundle. If we take the facts from the head note, two vessels were approaching each other on crossing courses at a joint speed of 20 knots, there being a difference of 17 degrees off the opposite courses. The K had the O on her starboard bow, and her duty was therefore to keep clear, while the duty of the O was to keep her course and speed. The K took no steps to get out of the way and narrowed onto the port bow of the O until the green light of the K was about ahead at a distance of about a quarter of a mile. The O, under the impression that K had allowed the time for Acton to go by and that she would keep her course and pass on to O's starboard side, starboarded and harder starboarded. At about the same time, K ported, and the O struck the K on the port quarter with her stem. Now, if we turn to page 414 of the report, we can see in the last complete paragraph, this is part of Viscount Finley's speech, another important contention raised for the Orduna, the O, was that the crossing rule had ceased to apply at the time when the O starboarded, the green light of the conniquary, the K, being ahead of or on the starboard bow of the O, so that they were no longer crossing vessels. The green light of the K was ahead of the O, but even if it had been slightly on the starboard bows, Articles 19 and 21 would not have ceased to apply. It appears to me impossible to say that these two vessels had entered on a new phase the moment the green light of the K got ahead, or even slightly on the starboard bow of the O. The conditions which render the regulations for crossing ships applicable begin as soon as the two ships, note the reference to the two ships, are approaching one another on courses, note the plural, which, if continued, may cause a collision. These conditions continue to subsist until the vessels have definitely passed out of the phase of crossing ships. One goes to 415. In the first complete paragraph, it was also contended for the O that the actions of the K were such as to convey the impression that she intended to hold on to her course, and that those on board the O were justified in acting on this hypothesis in trying to give the K a wider berth by starboarding. I am not prepared to adopt this view. It was, I think, too soon for the O, she is the stand-on ship, to conclude that the K, the give-way ship, would keep her course. Nothing had happened to prevent the crossing rule from applying. I am far from saying that cases may not occur in which the action of one ship may mislead the other to such an extent as to prevent the latter from being liable for an infraction of the rule. But in my judgment, nothing had occurred in the present case to bring the O within this principle. So that is a further decision of the highest court that supports the principle that both the putative stand-on and the putative give-way ship have to be on courses for the crossing rule to be engaged. I'd now like to show you a decision of the Privy Council to similar effect, the Pekin. That is in our authorities at page 743.
But just before you do,
yes,
Ms. Delveratnam, is there, and looking at the Orduna, is there a distinction between a ship being on a course, i.e. not stationary and moving in some direction, and being on a settled course? Because in the present case, the overall effect of the conduct of the navigation of the Alexandra was that she was proceeding in a broad direction, I think east, is it east-southeast? Whereas what is being spoken about in the ordiner is whether they're on a course at all.
Yes, well, Mr. Justice Tier, in his paragraph 70, concluded that it was difficult to describe what the Alexandra one was doing as a course at all. That is about 10 lines up from the end of that paragraph. And in my respectful submission, you have to be on a course in order for the crossing rule to be activated. And given Mr. Justice Tier's findings of fact, which were endorsed notwithstanding the challenge in the Court of Appeal and the inability of my learned friends to challenge those factual findings on this appeal, that the fact that the ordiner may be using language of settled course rather than course is really not material. If the give way ship is not on a course at all, let alone a settled course, and that is clearly the position from Mr. Justice Tier's unassailed factual findings, then the crossing rules cannot apply in my respectful submission.
We've all looked at the video which you helpfully showed us, yes?
Yes.
Of course, Mr. Justice Tier was able, with all the benefit of time and legal submissions and the enormous input of data, to ascertain precisely how the Alexandra's heading changed from time to time and how her course made good changed from time to time. But I wonder whether those refinements in what she was doing, bearing in mind that he also found that she continued throughout to be on a substantially steady bearing with the Eversmart, would be perceivable by the putative stand-on ship. All the stand-on ship might be able to see is that she was maintaining a steady bearing from an angle to the Eversmart's course, and therefore not stopped dead ahead, and therefore making some sort of progress which would, if it didn't change, and indeed as it did, ultimately lead to a collision.
Well, on the facts, my lord, there is no evidence that the Eversmart thought the Alexandra one was on a course. And indeed, when we look at the audio transcript, and in particular, the statement that's made by the master after the collision, which I referred to, I believe, yesterday. I think it was at page 243 of the audio transcript at 2348. He says that we hit her, i.e. Alexandra 1, because she stopped outside waiting.
Yes.
So what I would respectfully submit is that if it is not readily apparent to those on the other vessel that the putative give-way ship is on a course, and in fact that putative give-way ship is not on a course, as we know to be the case based on the factual findings, there is no basis for holding that the crossing rule should apply. And the legal position that flows from that is that looking at the authorities and those of the highest level, including the House of Lords and also the Privy Council decision in the Pekin, which I'm about to show you, the appellants are not able to satisfy one of the key preconditions to the application of the crossing rule, which is that both ships have to be on a course. And whether one describes that as a settled course or just simply a course really doesn't matter for my purposes because of the factual findings which have been found in my client's favour and which are not capable of challenge on this appeal. My lord, if I can move on to the Pekin, as I've mentioned, that's a decision of the Privy Council, and that is to similar effect as the decisions that I've already shown you. We can pick it up in the authorities bundle at page 743. The facts one can take from the head note. There's a reference there to Article 22, which was then the crossing rule. And the head note says, Article 22, which relates to vessels crossing so as to involve the risk of collision, must be distinguished in its application, firstly, as regards vessels navigating the open sea, and secondly, as regards vessels passing along the winding channels of rivers. In the latter case, the vessels must follow and must be known to intend to follow the curves of the riverbank. Held in this case that the defendant vessel, though she ported her helm, kept the course prescribed by the nature of the locality, and that at the moment of porting the vessels were not crossing vessels within the meaning of Article 22, since the reasonable inference, having regard to the locality and their previous courses, was that they would avoid collision, and the Leverington was considered and distinguished. Now, if we go to page 747 of the authorities bundle, internal page 536 of the report, we find the following statements made by Sir Francis Jern, who delivered the judgment of the court. The effect of Article 22, he said, has been made clear by several authorities. The cases of the Velocity, the Ranger, the Oceano have explained and illustrated the distinction which exists in the effect of this rule as regards vessels navigating the open sea and those passing along winding channels. The crossing referred to in Article 22 is, quotes, crossing so as to involve the risk of collision, close quotes. And it's obvious that while two vessels in certain positions and at certain distances in regard to each other in the open sea may be crossing so as to involve the risk of collision, it would be completely mistaken to take the same view of two vessels in the same positions and distances in the reaches of a winding river. I'm reading that because it's going to be relevant when we look at question 1 and the moment at which it can be said sensibly that any risk of collision arises through crossing. The reason, of course, is that vessels must follow and must be known to intend to follow the curves of the riverbank. But vessels may no doubt be crossing vessels within Article 22 in a river. It depends on their presumable courses. And then the next point is relevant to the submission I'm making now. If at any time two vessels, not end on, are seen keeping the courses, plural, to be expected with regard to them respectively, to be likely to arrive at the same point at or nearly the same moment, they are vessels crossing so as to involve risk of collision, but they are not so crossing if the course which is reasonably to be attributed to either, note the reference to either vessel, would keep her clear of the other. The question therefore always turns on the reasonable inference to be drawn as to a vessel's future course from her position at a particular moment, and this greatly depends on the nature of the locality where she is at that moment. What one derives from this case is a confirmation of the principle that both vessels, the putative stand-on as well as the putative give-way ships, have to be on a course to attract the application of the crossing rule.
But surely the main point he's making is about locality and that you take account of the circumstances of the locality. Though it wasn't suggested, was it, that one was drifting and therefore not on a settled course or course? He simply wasn't dealing with the situation with which we are concerned, of a ship moving but not necessarily on a settled course.
The reason for referring to this case, my lady, is because of the clear statement that both vessels have to be on courses. yes, it was not argued on the facts of that case, but one of them wasn't on a course and therefore didn't attract the application of the crossing rule. But the statement of principle is nevertheless clearly correct. And the fact that we had the avance, a decision of Justice Brandon, where that particular submission was being critically analysed, coupled with the House of Lords decision in the Savina, which likewise treats both ships as having to be on courses, is all part of the same picture, a consistent body of authority that shows that both ships have to be on courses. And I'll come on to this in a moment, but it was on the basis of those authorities, which are likewise supported in the devotion to and in Marsden, that at first instance, Mr. Turner QC, who represented the Eversmart interests, very properly made a concession that it was necessary for the fugitive giveaway ship to be on a course for the crossing rules to apply. Now, we had a spat in the Court of Appeal about whether arguments or concessions that were made below could be revisited, and I'm not suggesting that anyone should be held to that concession. But what I do say is that that concession by Mr. Turner was properly made on the basis of the authorities, not least of those which I've already cited to you.
But the point goes by default, and we're not really concerned, as you say, with concessions which were made below, and we're dealing with the question of law.
Correct.
But I find it difficult to extract from page 747 to 8 a statement of principle. All it says is if there are two vessels not end on keeping courses, then if they're expected to arrive at the same point, there's a risk of collision. That's not saying that's the only way you can apply the crossing rule.
Well, my lady, I'm obviously citing it because it's consistent with my case, but there isn't any case that my learned friend has been able to find, and I'll come on to the Broomfield, which shows that it is not necessary for the giveaway ship to be on a course. This is something which is heretical and is not supported by authority. And when we come to look at Marsden, which we know is a leading practitioner text and is a volume which all Admiralty practitioners have had on their shelves since they started in practice, it does not support my learned friend's case that giveaway ships do not need to be on a course in order for the crossing rule to apply. But before I turn to the Marsden expert, can I...
Just before you do.
Oh, yes. Sorry, yes.
Mr. Brown, I'm having some difficulty in understanding. I can well understand what the description of a ship that is waving around a bit as not being on a settled course means. But I find it very difficult to understand how it can be said of a ship that is making progress both through the water and over the ground, as the agreed acetate overlays in this case clearly show, isn't on a course. I mean, even if a ship was going around in a circle to pick up a man overboard, it would be on a course. It would be on a circular course. It might be making a Williamson turn, which is another kind of double man overboard course. And a ship going down a windy river, as in the Peking, is also on a course. I can quite understand that when nobody's seeking to set aside the judge's findings of fact. My difficulty is in understanding how he can describe a ship which is in fact moving both through the water and over the ground as not being on a course.
Well, I think the learned judge's point was that she wasn't on a sufficiently constant direction or heading to be on course.
That's a settled course. And you say that doesn't make any difference. But it seems to me that the judge's conclusion she wasn't on a settled course is readily understandable. The judge's description of her agreed movements, which are here for us all to see, that she wasn't on a course at all, I find very difficult to understand. He said it's because she was waiting. But you can be waiting on a course for a pilot vessel. You can be doing, in modern days, anything up to about 8 knots and still be waiting for a pilot vessel.
Well, my lord, I understand that you may not have reached the same decision on the facts as the learned judge in relation to a course. But my clients have been successful in having a finding of fact in their favour on the absence of a course, which was upheld by the Court of Appeal, again by an experienced Admiralty practitioner in his days as counsel,
Yes,
namely Lord Justice Gross.
Mr. Evergreen, can you just help me understand what it actually means in the context where we all agree that this ship was in fact moving both through the water and over the ground? What does it mean to say she wasn't on a course? I can absolutely understand what it means to say she wasn't on a settled course.
Well, it means that the other vessel would not be able to predict by reference to those changes in direction and heading how they needed to respond in relation to her. And in particular, it would not be sufficient to trigger obligations under Rule 17 in relation to avoiding action in circumstances where it was apparent that the other ship was not reacting in time to avoid collision. There is a correlative duty upon a stand-on vessel to take action under 17 2B, where the give-way ship is not taking action on her own to avoid the collision.
Yeah.
And in order to show that the vessel is in breach of that rule, it's got to be apparent that the give-way ship is on a course and acting in such a way as to trigger the existence of that obligation. The findings that the judge has made are to the effect that the direction and heading of the Alexandra I were not sufficiently constant or manifest as to trigger those obligations on the part of the Eversmart, and therefore the regime of the crossing rules simply did not apply to the encounter between the ships. I'll come on to show you those passages in our written case which show the intuitive appeal as a matter of common sense of requiring the give-way ship to be on a course, and indeed what led to our submission below, that it takes two vessels to cross. But if I could just show you the devotion to at the moment, which is in fact one of the authorities that my learned friend has inserted into the supplementary authorities bundle, which I don't know if you have as hard copy, but in my version, it's SAV 4 at page 25 and following. We have a decision of the Court of Session, Outer House in Scotland. The facts were looked at yesterday by my learned friend, and Marsden cites this case in a footnote as authority for the proposition that a stationary vessel is not on a crossing course. If one, however, goes to the report itself at page 28 of the bundle, we can pick up on the right-hand column at the end the argument advanced by the defenders. Mr. Bruce, for the defenders, advanced the contention that the rules placed vessels into two categories, those which were underway and those which were secured in terms of the definition. He argued that if a distinction was to be drawn between underway and making way, the rules did not cover the position of a vessel which was lying stationary at sea. I agree that in the event Rule 19, Rule 19 would not apply. I also agree with this contention that looking at the matter from a practical point of view, at first sighting, a stationary vessel would present the same aspect as one which was making way through the water. Indeed, if she was proceeding at minimum speed, the distinction with a vessel which was stationary could be an exceedingly fine one. It was for reasons such as these, it was argued, that the rule fell to be applied in the case in which the risk of collision arose, where one vessel was stationary, as well as in the usual case in which both vessels were making way through the water. Read literally, I find it difficult to construe the words, quote, when two power-driven vessels are crossing, so as to involve the risk of collision, ... as meaning anything other than that where two vessels are each pursuing courses, so reference to two vessels, each on a course, which, if maintained, involve the risk of collision. A course is not simply a heading, as Mr. Bruce suggested. It involves the concept of progress or passage. And indeed, I note that the shorter Oxford Dictionary includes in the definition the direction in which a ship sails. Support is to be found for this view in paragraph 818 of Marsden, where it's stated under the heading, when Rule 19, the crossing rule, comes into operation, that when two vessels not end on are likely, if each keeps the course to be expected of her, to arrive at the same point or nearly at the same moment, they are crossing so as to involve risk of collision, and the vessel having the other on her starboard side must take steps to keep out of the way. This passage is derived from the judgment in the case of the Peking, in which the President went on to say that they are not crossing if the course which is reasonably to be attributed to either vessel would keep her clear of the other. The question therefore always turns on the reasonable inference to be drawn as to the vessel's future course from her position at a particular moment. It is precisely because both vessels are on converging courses, plural, that the rule selects one of them as the give-way vessel and the other as the stand-on. In my view, the situation with a stopped vessel is entirely different. We then have Marsden, which is in our core bundle at page 966.1. It's paragraph 5-385. Which says when two such vessels are likely, if each keeps the course to be expected of her, to arrive at the same point at or nearly at the same moment, they are crossing so as to involve risk of collision at their speeds, and it seems the distance between them when they come into sight of one another are material, except insofar as they contribute to a state of risk of collision. This applies not only in the open sea, but also where two such vessels are approaching from different directions and on intersecting courses, a buoy, lightship, headland, or other point, at which each must, in the ordinary course of navigation, alter her course. So we have here practitioner text, which is consistent with both vessels having to be on a course. Now, my learned friend placed great stress on the Broomfield, but that is not authority for the proposition that a give-way vessel does not need to be on a course. If one goes to that decision, it's at page 356 of the authorities. We can see that the argument advanced by Mr. Aspinall, King's Counsel, on page 357, who appeared for the owners of the Lucania, was that the Broomfield was to blame and that the Lucania was stationary. And when the President gives the judgment of the court concludes, as we can see about 10 lines up from the bottom of the right-hand column, as follows. The question arises, what are the true facts? And when they are found, what rules apply? I think, and the elder brethren agree in this view, on the nature of the accident, that the vessels must have been slightly crossing. It is an absolutely unintelligible and almost absurd point to suggest that the Broomfield was coming down the channel with the Lucania's green light showing on the Broomfield starboard side, and that she, being bound down channel, would have any reason or desire to port and run into the Lucania. Therefore, that set of facts is not, I think, the true view to take. The true view is that the vessels were slightly crossing, and the Lucania was being helped forward by the southwesterly wind, which prevailed and which produced a certain amount of crossing on her part. When the facts are found in that way, you have a case of two steamers crossing, and the only question which it becomes necessary to consider is whether Article 19 applies. It's said that the trawler wasn't bound to keep out of the way because she was more or less stationed, and the case of the Helvetia is cited. Apart from the Helvetia, it's perfectly clear that these were both steam vessels under steam, and that they were crossing so as to involve risk of collision, and it was the duty of the Lucania to keep out of the way, and the duty of the Broomfield to keep her course and speed. So one can see that the Broomfield was a decision where, on the facts, it was resolved that one of the vessels was not stationary, but on the contrary, was on a course. And the Court of Appeal was correct to analyse the Broomfield as being a case where both vessels, the stand-on vessel and the give-way vessel, were on a course. If I could refer you to the Court of Appeal judgment at paragraph 91 in our bundle at page 172. Lord Justice Ross dealt with the Broomfield in this way. He said, in the Broomfield, the key question was whether the putative give-way vessel was more or less stationary. It was held that she was not, so that on the facts the vessels were slightly crossing and the crossing rules applied. A different conclusion was reached by Mr. Justice Brandon, as he then was, on the facts in the Avance, where he held that the crossing rules did not apply because the putative give-way vessel had been waiting off the harbour entrance and was not on any settled course at the time, nor was it possible for those on board the Avance to appreciate that she was. The Alcoa was cited. The give-way vessel was nonetheless seriously at fault for a very late manoeuvre, which resulted in her moving ahead of the Avance, but her liability wasn't based on the crossing rules. It may be we're not strictly bound by the observations in any of these decisions, some being obiter, and in the case of the Avance, a decision at first instance, albeit a decision of Mr. Justice Brandon. However, I do regard the observations as persuasive and respectfully agree with them. Although the position may not be as obvious as in the case of the stand-on vessel, I am nonetheless satisfied that both vessels, the give-way vessel included, must be on a sufficiently defined course for the crossing rules to apply. That is the essence of the crossing rules. The need for an appreciation of the situation is not confined to the give-way vessel, and we would respectfully endorse that, my lords. The stand-on vessel must be in a position to appreciate her own status as such, and additionally may be required to make a judgment call in the light of the action taken by the give-way vessel under Rule 17A2, and that should be a reference to little b, not little 3. The mere fact that there was a risk of collision through convergence is not determinative of whether the crossing rules apply. Put colloquially, in my language below, it takes two to cross. I would respectfully submit that that statement has the attraction of simplicity, common sense and consistency with the authorities. And in the light of the factual findings made by the learned judge, which were approved and endorsed by the Court of Appeal, shows that this is not a case where the crossing rules apply to the encounter because the Alexandra one was not on a course or a sufficiently defined course as to attract the regime of the crossing rules in the way that the court has found would be required. So that, in my respectful submission...
Can I just, just before you go on, Ms.
Yes.
Beltram, can I just be absolutely clear then what you're saying about the Broomfield? As I understand it, you're saying that the give-way, the putative give-way vessel was on a sufficiently defined course at the relevant time?
Yes, that was what the conclusion of fact was of the court in that case. As the court says at the top of page 358, the true view is that the vessels were slightly crossing and the Lucania was being helped forward by the southwesterly wind which prevailed, which produced a certain amount of crossing on her part. And when the facts are found in that way, you have a case of two steamers crossing.
Because I think you could probably see that the facts of that case do look somewhat analogous to our own case. It looks as if we've got a ship that's waiting, that's drifting across in some sense, but the court there, you're saying, is satisfied that they're on, that the giveaway vessel is on a course.
But it's infinitely a factual decision for the trial judge, and there's no indication of varying heading by the giveaway ship in the Broomfield, which of course is a characteristic of the Alexandra One's aspect in the present case.
It's common ground, isn't it, and was found by the judge that in this case, in our case, the two ships were crossing with a risk of collision, because he found that they maintained a substantially steady bearing to each other and were approaching each other. So that the conclusion that there was slight crossing is a finding of fact in this case, obviously correct, because eventually they did collide. And one has to understand, when the judge says they weren't on a course, one has to understand in the light of the fact that he also concluded that they were crossing. For my part, I don't understand how a ship which is not dead ahead of you, but which is nonetheless on a crossing with you, can't be on a course.
Well, my lord, my answer to that is that the court has found, consistently with the correct approach to what is a course, that these vessels were not crossing within the meaning of the rules, because it's not sufficient for there simply to be a risk of collision. To attract the regime of the crossing rules, one has to have both vessels that are on courses which will lead to them crossing. It takes two to cross, and unless the giveaway ship is on a course for the purposes of attracting the regime of the crossing rules, and in turn giving rise to obligations on the stand-on vessel under Rule 17, there has to be a sufficiently settled and defined course, which was simply absent on the factual findings made by Mr. Justice Tier. Now, one might think that there is some superficial similarity with the description that one has in the old case of the Broomfield, but one simply does not know sufficient of the detail of the facts there to form any view that there is an inconsistency between the conclusion drawn from the facts in the Broomfield and the conclusion drawn by Mr. Justice Tier from the facts that he found based upon all the very detailed course and heading information that he had before him. And of course, it is also relevant to know that the Eversmart did not suggest that she thought that the Alexandra One was on a course, nor was it suggested in witness evidence from the Eversmart that the Eversmart's master considered that he was entitled to assume the role of a stand-on vessel. That was completely absent from this case.
I'm sorry to interrupt, but it's not the relevant test. The objective conclusion to be drawn from properly looking at the information which is available to you, rather than what the crew of the stand-on vessel actually thought. I mean, one possible view about what the crew of the stand-on vessel actually thought was that they didn't really see the ship properly until the last 30 seconds. But you very helpfully showed us what her radar was showing, which was showing two vessels approaching each other on a steady bearing, and thereby creating a risk of collision.
My lord, I come back to my point that risk of collision is one ingredient, but only one ingredient.
I'm sorry, you're quite right. Sorry, not just approaching each other on a steady bearing, but crossing on it. They weren't end on, they were crossing on a steady bearing and therefore causing a risk of collision.
Well, my lord, I appreciate that you may not have reached the same conclusions on the facts as Mr. Justice Tier, but he was the trial judge. He examined a whole raft of evidence, including the detailed navigation of the Alexandra 1 and what would have been apparent to the Eversmart from all of the material that would have been available to the Eversmart, not simply the video that we saw yesterday. And his conclusion, which is one of fact and which is not challenged, is that she was not, the Alexandra 1 was not on a sufficient course in order to justify the operation of the crossing rule regime. And as the court has found, everyone knew that Alexandra 1 was waiting for a pilot to go down the channel. And that piece of information, which was common ground, obviously informs the factual finding that what was observed on the radar did not amount to a sufficient course as to give rise to the satisfaction of one of the criteria in the crossing rules to make that regime applicable. There was not a course adopted by the Alexandra 1.
Well, so far as the management of the ships is concerned, there are no doubt points that can be made on either side, but they don't help the point of construction. I would like to understand why it is that a give-way vessel, which is not anchored and not moored, but is in the water and moving in the water, cannot give way, because I think that's the only practical difficulty that you have pointed to. It is Rule 17, subparagraph D. It's got an obligation to stay out of the way, the very important obligation. But if it's in the water and it's not tied up, why can't it actually move out of the way?
Well, this may be something on which you may benefit from speaking to the nautical assessors. But we know here that this is a pilot boarding area with laden ships waiting to take on board a pilot before going into the channel. Such vessels are typically not very manoeuvrable, and to impose upon such vessels an obligation of keeping out of the way would be inconsistent with the seamanship advice which was received by Mr. Justice Tier first instance, which showed how you would expect vessels who were about to proceed down the channel to behave. And that is to approach the channel so that when the channel is entered, they are on the starboard side of the channel.
Yes, but that's caveated, isn't it? They say subject to visibility and lookout, and that presumably has some implications for this debate.
Well, I'll come on to the seamanship advice very shortly, because I'm going to be turning on to the importance of that when looking at question 1. But the seamanship advice which was given to Mr. Justice Tier and which justified his conclusions that this was not a crossing situation was in the following terms. If one goes to 214 of the first instance judgment, this is page 214 of our bundle, paragraph 93, I asked the elder brethren the following question, and just by way of background, which is in fact apparent from the preceding paragraph in the judgment, it had been Mr. Turner QC's case that there ought not to have been an attempt by Alexandra 1 to proceed to within a certain minimum distance of the number 1 buoys, because that is what would be inconsistent with the duty of a give-way ship. And the judge asks the elder brethren the question set out at paragraph 93 of the judgment. Did good seamanship require the Alexandra 1 to keep a certain minimum distance from the number 1 buoys, so long as the Eversmart was still in the dredged channel, and if so, what was that distance? And they advised as follows: subject to a good oral and visual lookout, it would be reasonable and good seamanship for the master of the Alexandra 1 to have approached the first pair of buoys, keeping close to her own side of the entrance channel. So there's nothing there which suggests that the vessel in the situation of the Alexandra I ought to give way, ought to hold back and give priority to the Eversmart coming out of the channel. And that seamanship advice was critical in forming the view that the construction of the collision regulations, which are endorsing good seamanship and endorsing safety, did not require safety with the give way obligation to be imposed on the Alexandra I. That was not what good seamanship required. All that good seamanship required in terms of an encounter between a vessel outbound in the channel and another vessel that was intending to enter the channel is what the elder brethren advise, that subject to good oral and visual lookout, it would be reasonable and good seamanship for the master of the Alexandra I to have approached the first pair of buoys, keeping close to her own starboard side of the entrance channel. And in my respectful submission, the fact that that was the nature of the duty shows that it is not necessary to impose a separate duty to give way on the part of the Alexandra I. Imposing such a duty would be inconsistent with what the elder brothers advised was the appropriate duty of the Alexandra I. And the fact that the Alexandra I may not have complied with that duty fully in this case and was penalised for it, being found 20% to blame, does not alter the regime that she was subject to. She was subject to a Rule 2 good seamanship obligation of lining up appropriately and then entering the channel as close to her own starboard side as possible, consistently with Rule 9. And as the judge says at 95, I accept that advice. It's consistent with the opinion of Lord Clark, again, very, very distinguished Admiralty judge, in the Culler Mason case, as to how a vessel should approach a narrow channel. An incoming vessel which is approaching the dredged channel can expect to pass an outgoing vessel safely port to port if it approaches the channel in such a way that she keeps to the starboard side of the approaches, so that on entering the channel, she is on the starboard side of it. Keeping a certain distance from the channel while another vessel is in the channel is not required to achieve a safe port-to-port passing. So
But
that is
the
why...
point, sorry, isn't that the point? That the hypothesis of the question is, does there need to be a minimum distance from buoy number 1, so long as the Eversmart is in the dredged channel? And the answer which comes back addresses that particular point and is also caveated by subject to a good oral and visual lookout. So I had thought, and you may want to help me on this, that if something appears when the ship has left the channel as a result of maintaining the good oral and visual lookout, then a different answer may apply. That one can't rely on this answer for dealing with the question of what the circumstances that actually happened in this case following exit from the channel.
My lady, I would respectfully submit that this answer does directly apply to the encounter. If you have the counter scenario, which my learned friend is advocating, of the crossing rules applying, the duty upon the Eversmart would have been to maintain her course and speed. We know that she had been adopting the port side, the wrong side of the narrow channel, for 10 minutes before collision. If you construe maintaining course and speed in the way that Alexandra I would reasonably have expected it to be construed, seeing a vessel coming towards her on the wrong side of the channel for 10 minutes before the collision, you cannot assume that the Eversmart is suddenly going to assume the starboard side of the channel. That is not something which would be expected or anticipated by her. likewise, if the maintenance of course and speed obligation is imposed upon the Eversmart, you have the real concern that she is going to be ploughing into a pilot boarding area as she emerges from the narrow channel at full sea speed, where she will be encountering and expect to encounter vessels similar to the Alexandra one, which are laden, not very manoeuvrable, and which will have difficulty in keeping out of the way. And the Court of Appeal was very conscious of that consideration, and I will be showing you in due course, I think it's paragraph 64 of the Court of Appeal's judgment, where Lord Justice Gross was expressing concern about the potential for confusion if the putative give-way vessel is faced with a putative stand-on vessel lingering to port of mid-channel, and also the risks of emerging at full speed in a pilot boarding area.
But with respect, sorry,
yes.
before you go on to deal with the inconsistency, which is a major point, when you look at Rule 17, yes, the stand-on vessel has to keep her course and speed, but that is subject to Rule 2. So you can't just put your foot on the accelerator or whatever the maritime equivalent might be and go full speed without taking into account the dangers of navigation. And Rule 17 has to be given that sensible construction, surely. So if they found a trawler sort of fishing slowly in front of them, they couldn't just maintain their full course and speed directly into the trawler.
But good seamanship and the Rule 2 obligation informs what the regime is. My learned friend in his submissions to you has sought to suggest that the crossing rule regime has some paramountcy. It does not. Rule 9 is an equally important rule to observe, and it is no less important than the crossing rule. And as Lord Clark in the Culler Mason has found, and consistently with the approach of Mr. Justice Hewson in the Canberra Star, where you have vessels encountering each other in the vicinity of a narrow channel, you have to have a separate regime applying from the crossing rule, because the crossing rule can give rise to inconsistency and conflicting obligations on the vessel that would be in the position of the stand-on ship. And that the reason you have this different regime applying in the vicinity of a narrow channel is safety. And safety underpins the approach that one should take to construction of the collision regulations, not a literalist approach to the words that have been used in the collision regulations, because these are intended to be an international instrument with safety at their core, and which encourages an international consistent approach to their interpretation. We will submit in relation to the appeal on question 1 that the fact that Lord Clark in Culler Mason considered that a separate regime, not the crossing rule regime, applied in the vicinity of a narrow channel and vessels that were liable to encounter each other in that vicinity is very powerful in favour of the conclusions which have been reached by our experienced Admiralty Judge, Mr. Justice Tier, and by Lord Justice Gross and the remainder of the court in the Court of Appeal, that the crossing rules simply do not apply here, because that would not foster safety because of the risk of confusion and conflicting obligations arising. So I will come on to look at those authorities in more detail with you, my lady. But I would reiterate that question 2 is a freestanding ground. This is not the court to revisit findings of fact and conclusions about whether there was a course, nor is this the court that ought to be drawing parallels with the Broomfield, where we know too little about the detail of the course in the Broomfield, and we know so much about the course of the Alexandra one, because it left the Admiralty judge, who had looked at the question of whether she was on a course in detail, with the conclusion that because of the variations in heading as well as direction, it was not sufficient to trigger the activation of the crossing rules. So,
can I just...
Ms. Salvaretnam, am I right in thinking that the Broomfield was not cited in the Avance or in the Savina?
I think you are correct, my lord. I can just check.
Well, it's something we can check ourselves anyway.
Yes, I don't believe it was. I mean, it is a case which we say is being relied upon in this court and in the Court of Appeal for a proposition which it doesn't fairly stand for, because it was a decision on its facts about whether the Broomfield was stationary or was in fact underway and on a course, and therefore it would not have been particularly pertinent for that case to have been cited in support of a legal proposition. I don't see it referred to in the Savina as one of the cases that was referred to, and in the Avance it doesn't appear that it was referred to.
It doesn't appear from the report. That's right. I think it's Lord Briggs. Thank you. Lord Briggs has a question.
Yes. I just want to make sure I understand how your submission on issue 2 fits with the rule itself, which says that when two power-driven vessels are crossing so as to avoid a risk of collision, then the consequences follow. Are you saying that when a ship is proceeding slowly and slightly erratically, but is nonetheless, in fact, as we can all see, crossing over the course of another ship which is on its starboard side, that they're not crossing? Or are you saying that they are crossing, in this case by common consent so as to avoid a risk of collision, but nonetheless the crossing rule doesn't apply? Which is it to be?
What I'm saying is that the course that was observed on the video, which Mr. Justice Tier concluded was not sufficient to trigger the crossing rules, was not sufficient to enable you to predict whether the relative movement of the two ships was such that it will result in them crossing, because you have to have both of them on a settled course in order to make that prediction. And that is why you have to have a crossing situation only when vessels are moving relative to each other in a way which will result in one vessel predictably crossing the path of the other. That is what we say in relation to the finding of the judge and how it fits into the scheme.
So I think you're saying, in answer to my question, but don't let me put words into your mouth, that the erratic nature of the Alexandra's course was such that they weren't crossing.
Within the meaning of the rule, yes.
Yeah,
correct.
Thank you. Yeah.
Correct.
So we'll take a 5-minute break at that point, if that's convenient.
Yes, of course it is, my lord. Yes, thank you very much.
Salvaretnam.
Thank you. My lords, just before leaving question 2, could I draw attention to our written case at paragraph 122, which is at page 133 of the core volume, where we refer to an analogy with a case called the Sestriere, in which a vessel was dropping off a pilot and was held not to be on a crossing course. For present purposes, I'm not going to take up the case, but refer you to the quotation from Mr. Justice Brandon's judgment that we've set out in paragraph 122, where he said, "I'm not satisfied that the Alonso ever settled on such a course." The Alonso, on the facts of that case, was the stand-on vessel, so it doesn't directly help us here. But what he says is she was manoeuvring to drop her pilot, and for this purpose was, it's true, proceeding slowly ahead on a northerly heading. On the other hand, she was free to adjust her heading as she might wish after doing so. We would respectfully submit that you shouldn't be seduced by the fact that you may have seen the Alexandra 1 tracking southeasterly into concluding that she was on a settled course for the purposes of the crossing rule. The Alexandra here was manoeuvring and able to retain her freedom of movement while she was waiting for the pilot. She was free to adjust her heading as she might wish after boarding the pilot. And that is a point which was no doubt not lost on Mr. Justice Tier when he concluded that the variations in heading and aspect were such as not to constitute a course for the purpose of the crossing rule. So if I may now turn to question 1. Do the crossing rules apply to the encounter between the Alexandra and the Eversmart, given the locality in which they occurred? We respectfully support the analysis and conclusions of Mr. Justice Tier and the Court of Appeal, and there is no tension between the approaches of the lower courts, contrary to what has been suggested by my learned friend. The Admiralty judge, highly experienced, Lord Justice Gross, also a wealth of Admiralty experience while he was at the bar. And both courts had the benefit of advice from nautical assessors who endorsed an approach to the narrow channel navigation, which was consistent with Rule 2 applying to the Alexandra and not the stringent requirements of the crossing rule. Now, the fact that the conclusions of the Admiralty judge and the Court of Appeal were supported by the seamanship requirements of Rule 2 and the advice from the nautical assessors is highly important. And this is because of what Rule 2 provides. Rule 2, little a, says that nothing in these rules shall exonerate any vessel or the owner, master or crew thereof from the consequences of any neglect to comply with the rules or of the neglect of any precaution which may be required by the ordinary practice of seamen or by the special circumstances of the case. And Rule 2b is directly relevant to the way in which you approach construction of the rules. It says that in construing and complying with these rules, due regard shall be had to all dangers of navigation and collision and to any special circumstances, including the limitations of the vessels involved, which may make a departure from these rules necessary to avoid immediate danger. Now, the fact that Rule 2 makes clear that mariners are not required or even permitted to comply with, for example, the crossing rule or any of the other rules, where to do so would be to neglect the requirements of good seamanship, is highly material. And it is noteworthy that my learned friend in his address to you has rather marginalised the significance of Rule 2, as has his written case. Now, the seamanship advice that's been given here is very important, and I'm going to focus upon the advice that was given in relation to this encounter, the west-east encounter, but it's also relevant to look at the east-west encounter, which is equally relevant if you consider it appropriate to stress test the conclusion on different facts, because both sets of advice do not suggest that you have a straitjacket of crossing rule obligations to perform. On the contrary, they devise a regime which is informed by good seamanship and Rule 2. So, Mr. Justice Tier, taking this point first, it's the passages that we looked at a short while ago, which I was addressing Lady Arden in relation to. It's paragraphs 93 to 95, the bundle, page 214. And just to remind you, the advice in 94 was subject to a good oral and visual lookout. It would be reasonable and good seamanship for the master of the Alexandra to have approached the first pair of buoys, keeping close to her own side of the starboard close to her own side of the entrance channel, that is the starboard side. Now that reflects also the seamanship advice that was given to the court in Culla Mason, and that consistency is noted by Mr. Justice Tier in paragraph 95. When you are considering whether it is appropriate to hold that the crossing rule applies to this encounter, rather than the view that has been taken by the Admiralty judge, endorsed by the Court of Appeal, and which has an edifice of support in the Culla Mason case and also the Canberra Star, one must be aware that safety is paramount and consistency of approach in seafaring nations in approaching questions of construction of the collision regulations is paramount. My learned friends in their appeal have failed to face up to the fact that the seamanship advice given by the lower courts and in Culla Mason is incompatible with the application of the crossing rule. There's been no appeal against that seamanship advice. Eversmart resorts to seeking to marginalise the seamanship advice by saying it's not relevant to construction, but we say it is central. I've read to you Rule 2A, which says that nothing in the rules shall exonerate a vessel from the consequences of a neglect of any precaution which is required by the ordinary practice of seamen. The corollary of that is that if good seamanship and safety requires action from either ship which is inconsistent with the crossing rules, then the crossing rules cannot apply. And that is because promotion of safety is at the heart of the collision regulations. Now, my learned friend's sensitivity about the implications of the seamanship advice has extended to even suggesting that there is no need for elder brethren or nautical assessors on this appeal. And you'll recollect what is said in their written case at paragraph 11. We say the advice of the nautical assessors is critical and will ensure that this court does not go wrong in crafting a regime which does not have the practice of seamen and safety in navigation at its heart. A further point that we would make in relation to construction is that my learned friend has said that Rule 2 cannot be used to displace the effect of the crossing rules if they apply as a matter of construction. But that is to turn Rule 2b on its head, because Rule 2b provides clearly that in construing and complying with the rules, you have to have regard to all the dangers of navigation and collision and to any special circumstances, including those which may make a departure from the rules necessary to avoid immediate danger.
Lord Briggs has a question.
Oh, yes.
I can well understand. I'm just looking at Rule 2b for the moment.
Yes.
I can well understand how all the dangers of navigation and collision help one construe the rules, and how special circumstances, including limitations, may make a departure from the rules necessary is relevant to complying with the rules. But I'm in a little difficulty in understanding how particular special circumstances really make much difference to construction.
Well, let me address that. Special circumstances will include the fact that this channel has its entrance and exit in a pilot boarding area. That is very relevant for the reasons noted by the Court of Appeal in paragraph 77 of the judgment at page 168 of the bundle. What Lord Justice Gross, giving the judgment of the court, says there, Eversmart was duty-bound to keep as far to the starboard side of the narrow channel as safe and practicable, that's Rule 9, so as to exit safely. Her navigation in the channel was governed by Rule 9. For that matter, had the crossing rules been applicable, there might well have been concern at the prospect of Eversmart maintaining course and speed as it exited the narrow channel through the pilot boarding area. Now, that is a special circumstance which clearly is relevant, to which the court is entitled to have regard under Rule 2, and which no doubt informed the seamanship advice which was given to both the lower court and the Court of Appeal as to how one ought to approach an encounter in the vicinity of the approaches to a narrow channel. Rule 2 is explicit in requiring it to be construed, and the rules as a whole to be construed with all dangers of navigation and collision in mind. And in relation to interpretation, the learned judge below, Mr. Justice Tier, said to have two sets of rules with different requirements applying at the same time is unsafe and cannot have been intended by those who drafted those rules. And he refers in the succeeding paragraphs to the fact that Rule 2 mandates regard to be had to all dangers of navigation and collision. And he says that one such danger is the risk of collision created by two rules potentially requiring different action at the same time. And the inconsistency of action is manifest where you have a vessel in disregard of her obligations under Rule 9, such as the Eversmart, proceeding on the wrong side of the channel for 10 minutes before collision, and a vessel that, like the Eversmart, disregarding the advice from her own pilot to moderate her speed, that decides to increase speed to full sea speed after dropping that pilot, such that she is over 12 knots at the point of collision. Mandating keeping course and speed in that type of scenario is not going to promote safety. And it's not an answer to say, oh, well, maybe you wouldn't be criticised for not maintaining your course and speed because of cases like the Roanoke that show when you are engaged in a particular manoeuvre, you can engage in that manoeuvre without breaching the obligation to keep course and speed. But that misses the point. Here, the Eversmart was engaged in proceeding up the channel for 10 minutes on the wrong side and increasing speed for nearly 10 minutes in breach of duties of good seamanship. And there is no qualification in the cases which have considered the meaning of course and speed in the crossing rules that would readily lend themselves to the Eversmart suddenly regaining the starboard side of the channel or suddenly putting the brakes on. It's quite clear that Eversmart did not regard her duty as anything other than proceeding in the way she did, on the wrong side of the channel for 10 minutes and at great speed. And in order to promote safety, the court and the elder brethren who were advising have advised that the crossing regime is not the one that applied. When a vessel is in the channel, the regime that applies to the channel vessel is Rule 9. When a vessel is approaching the channel with a view to entering it, the regime that applies is Rule 2, good seamanship. And good seamanship requires that vessel to prepare to enter the channel in a manner that would then satisfy her obligations under Rule 9. There is no need for imposition of the crossing regime to foster safety. And indeed, having an additional layer of conflicting obligations imposed by the crossing rule can lead to confusion and difficulty. And that is what was powerfully in mind of the lower courts when they were dealing with the risk of conflicting action that's caused by having two sets of rules. My learned friend, in his written case at paragraph 72, has suggested that we cannot cite a case where there would be inconsistency between what the crossing rules require and what good seamanship requires. But we respectfully submit that the relevant example is this very case. You have a putative give-way ship, laden, not very manoeuvrable, like Alexandra I, in the pilot boarding area with minimal way on, waiting for the arrival of a pilot cutter, and hasn't yet commenced manoeuvres to line up to enter the channel. She hasn't yet commenced her turn to starboard to line up for the channel. A stand-on ship, like the Eversmart, on the wrong side of the channel, speeding straight for our vessel. If Eversmart is correct, it's incumbent on our vessel to keep out of her way, notwithstanding her manifest breach of Rule 9 and her manifest unsafe speed. According to Eversmart, she is entitled in that situation to rely on the crossing rule to place the onus on my ship to keep out of the way, notwithstanding that I am not very manoeuvrable and cannot keep out of the way readily. And everybody knows that what I'm doing is waiting for a pilot seeking to enter the channel. That is an unsafe situation and shows why in this situation you cannot simultaneously apply the crossing rule as well as Rule 9. Turning to our written case, it may be appropriate just to remind you of what we say there at paragraphs 20 and 21.
Before you leave that point, what are other examples you want to give us in relation to how the rules?
Oh, I'm sorry, I'm actually not able to hear at the moment. I don't know whether there's an issue with...
You're unmuted now.
Ah. Can you hear me?
We can hear you, Mr. Ratnam. I think Lord Hampden was muted, but is now not muted.
Can you hear me?
Not very well.
Can you hear me at all?
Yes.
Very faintly.
I also, sorry to interrupt, can barely hear your lordship.
I think I heard. Would you like me to repeat the question?
Can you hear me now? Can you repeat the question, Lord?
Yes. Lord
Sorry.
Hampden asked whether you could offer any other examples than the one you've just given of the incompatibility between Rules 9 and 15.
Well, apart from showing that Rule 9 requires a vessel to proceed on the starboard side, and a crossing rule can mandate a vessel to proceed on the wrong side of the channel but keep her course and speed if she is in a crossing situation. That is the prime example of where the conflict will arise, because Rule 9 is concerned with channel navigation and the starboard hand rule. That's why I've given that particular example. But that potential for conflict is sufficiently serious and can arise in any channel vessel encounter with a vessel seeking to enter the channel as to mandate long and hard thought as to whether it is prudent to impose on vessels encountering in that circumstance a crossing rule obligation. Lord Clark in Cullamason considered that it was unarguable that the crossing rules applied. And we will see if the navigation of the YH vessel in that case was so different from the Alexandra I in our case. In my respectful submission, it was not so different. The only difference was that we were waiting to pick up a pilot, whereas the YH was underway. It would be extraordinary if the regime which was thought to be safe in the Cullamason was completely disapplied on the facts of our case simply because Alexandra I was waiting to pick up the pilot, whereas the vessel in the Cullamason was already underway.
Miss Selvarapnam, just before we go further, we're looking at a question of construction.
Yes.
Specifically, the interaction between two rules in the same code.
Yes.
And the question whether they're incompatible. And as a question of construction, one's answer should be broadly applicable across the board. unless there are special exceptions. In such a context, is it right to look at the question on the assumption that one or both vessels are flouting the rules, or on the assumption that both vessels are concerned to comply with them?
Well, one has to approach it by reference to the known fact that collisions happen and that not everyone behaves in a seaman-like manner all of the time. And both the lower court and the Court of Appeal were very conscious that there were potential conflicting requirements of the crossing rules and Rule 9. And Mr. Justice Tier, at paragraph 52, for example, said that where one vessel is within a narrow channel and has a vessel on her port bow on a crossing course outside the channel, but proceeding towards it in preparation for entering it, the vessel in the narrow channel cannot be under a duty under the crossing rule to maintain her course and speed, and at the same time under a duty pursuant to the narrow channel rule to keep to the starboard side of the channel, since the two duties may, depending on the circumstances, require different action. As Lord Clark said, there would be considerable scope for confusion. The Empire Brent, which was quoted by Mr. Justice Tier in paragraph 42 of his judgment, likewise recognises that the requirements of the narrow channel rule and the crossing rule are different. The potential for conflicting requirements was considered by the Court of Appeal to be very apparent. In paragraph 62 of the Court of Appeal's decision, which perhaps we could usefully turn up now. It's paragraph 62 at page 164. Where this is Lord Justice Gross says, keeping in mind the object and terms of the collision regulations, an obvious concern would be, as the judge expressed it, two rules potentially requiring different actions applying at the same time. Crossing rules require the stand-on vessel to keep her course and speed. The narrow channel rule requires a vessel proceeding in the channel to keep to its starboard side, so far as is safe and practicable. Potential for conflicting requirements is apparent. He goes on to say it's to be acknowledged, as Mr. Jacobs contended, that keeping course and speed isn't to be interpreted literally, and it might be said unthinkingly, and then he refers to the Roanoke and the Taunton, and Lord Wright's observations in the Alcoa Rambler. But he goes on to say at 63.2, however, even allowing for the impact of these authorities on the interpretation of the crossing rules, I'm wholly unable to accept Mr. Jacobs' submission that there was no risk of any such inconsistency here by reason of the precise manoeuvres undertaken by Eversmart as she proceeded along the channel. It is the situation as a whole that falls to be considered, and it is to my mind unrealistic to suggest that there was no risk of the narrow channel rule and the crossing rules potentially requiring different actions at the same time. It must be unlikely that a proper application of the collision regulations would place a seaman in an invidious position of this nature, that a particular course correction, for example, a one-off obvious and decisive manoeuvre to regain the starboard side, might not be inconsistent with both rules, seems to me to be neither here nor there. In any event, were both rules to be applicable, the scope for confusion for the putative give-way vessel, faced with a putative stand-on vessel lingering to port of mid-channel, is considerable. Now, my learned friend rhetorically and forensically said that that was not understood. But if you put yourself in the shoes of the Alexandra I, seeing a very large vessel approaching on the port side of the channel, and bearing in mind that the Eversmart had heard a VHF fall, which led him to think that someone was going to be trying to go round his stern and therefore keeping to port of the channel, would have been very much misled by what he saw and would have caused considerable confusion as to how she should act. The reason that the narrow channel rule is given such priority and emphasis in the decided cases is because the starboard hand rule promotes safety. And if you are to sanction a maintenance of a 10-minute wrong side of the channel course by Eversmart, which the keeping course and speed rule could do on one view, that would not be something that would foster safety and would certainly generate confusion in the mind of those on the other vessel as to how to take action in relation to her. If I could now just remind you of what we say in relation to the correct approach to construction in paragraphs 20 and 21, we fully accept that you don't adopt a narrow or English law-based manner of construction. What you do, as we say in paragraph 21, and as we advocated to the courts below, is the approach set out in Marsden. You note that the rules are international in character, and you note that they have to be interpreted by the courts of many different countries. The second point is that the primary object is the prevention of collisions at sea, not the determination of liability after the event, and therefore a uniform construction is desirable. We relied upon those very passages in Marsden in the courts below in order to emphasise that promotion of safety of navigation was the paramount approach to adopt, and the fact that you need to have an international approach suggests that you should apply foreign decisions such as that of the Court of Final Appeal in Hong Kong, presided over by Lord Clark, where they are considering similar fact situations. And if you are adopting that approach, then you will reject my learned friend's appeal in relation to question 1. The underlying rationale of the narrow channel rule, Rule 9, has been insufficiently factored in to my learned friend's presentation of his case. The fact that you have an encounter here between a vessel emerging from a narrow channel and a vessel in the pilot boarding area preparing to enter that channel ensures continuity and a seamless entry into the channel if you adopt the extension principle, which Lord Clark did in Mason, and the seamanship principle that is very similar to that extension principle adopted by Mr. Justice Tier and the Court of Appeal in our case. The Court of Appeal... I'm sorry.
Would this be a convenient point where I could just ask a question about the operation of Rule 9? Rule 9 gives one instance and one instance only of when there shall be priority, and that's in paragraph D.
Yes.
You shan't cross if that would impede the passage of a vessel which has to have the deep water, as it were.
Yes.
Could I just ask you, if you say that Rule 9 applies to the exclusion of the crossing rules in the vicinity, you are saying that it applies beyond the continuity principle, as described by Mr. Ray. And I appreciate you're going to address us on what that is, but he's taking the factual paradigm where one ship has lined up or shaped up to come into the channel from that point and that point only. But the judge's wording, vicinity or the area of the channel, is a very much broader situation. I was just going to ask you, really, we're focusing on the relationship between the Alexandra one and the Eversmart, but as a matter of construction, what happens to all those other ships that are around the entrance to the channel? We know about the Zakir Bravo, and I suspect there were other ships being shown on your video yesterday, or the stills would have shown other vessels. But if you think about a busy river like the Mersey, you have a deep channel down the middle, and you have a lot of crossing traffic from one side to the other. And formerly, you will recall, there were ferries across the Mersey, and there may still be some. But it's a very, very busy waterway. Now, suppose that there were other ships who want to know which rule to apply. If the exclusion of the crossing rules is as broad as the judge has held, what are their obligations? What's going to happen? Are they going to have to look at the narrow channel rule and work out what good seamanship would require? Or are they going to apply the crossing rules by analogy, or are they without guidance? Are they confused?
Well, obviously those on board the bridge of vessels navigating in the channel will be applying Rule 9, and they will be very familiar with principles of good seamanship. The particular Rule 9D situation is contemplating a crossing within the narrow channel itself, not in an approach to a narrow channel. That is the specific situation which is envisaged in 9D. Where you have a situation of an approach to a narrow channel from outside of that narrow channel, and you have to look at whether you look at Rule 9 or you look at a crossing rule or you look at Rule 2, it is in that situation where the courts have considered there is a level of uncertainty, and the case law that has considered the particular scenario of a vessel approaching a narrow channel with a view to entering it are those cases which support my client's case in relation to the applicable regime. They are the Canberra Star, the Culla Mason case, and those principles which were applied in those cases as found by Mr. Justice Tier and the Court of Appeal, advised by their respective nautical assessors. So it is good seamanship that applies to guide the navigation of the vessel coming in. We know that the vessel coming in will have to comply with Rule 9 when she gets into the channel. How does she get into the channel in a manner that fosters safety? She gets in by proceeding in a way that will enable her to enter the channel on her starboard side. It is not a rule that is imposed by the crossing rule. That is not the relevant regime. And the reason it's not the relevant regime is because it would give priority to the stand-on ship to make anyone that was in the appropriate position of a putative give-way ship keep out of the way in circumstances where they may not readily be able to do so and have no realistic expectation of being able to do so because they're heavily laden, they have very little way on, they're not very manoeuvrable, and a pilot boarding area can be quite crowded. On the contrary, the regime that applies and which fosters safety is one of good seamanship. And what that requires is what the nautical assessors advised the judge about, and which was set out in paragraph 93 and 94 of Mr. Justice Tier's judgment, consistent with what the same nautical advice was given to the court in Hong Kong in Culla Mason.
Yes, Lord Burrows.
Yes.
Yes, it may not be the best time for me to ask this question, but it does sort of follow on from Lady Arden's question. Clearly, you are defining the ambit of the narrow channel rule in such a way that it extends to, I think, what you've described or has been described below as in the vicinity of
Yes.
the narrow channel. Now, at some point, I assume you will be conceding, inevitably, that the crossing rules must kick in at some point once one's outside the vicinity of the narrow channel area. But what I'm interested to know is, what do we mean by in the vicinity of the narrow channel? At what point do you say that the crossing rules kick in? Has this got anything to do with the intention of the ship coming in, or is it a purely geographical approach? Has the pilot boarding area got anything to do with that? All these questions, I would really need some help from you if you can address them, please.
Yes. Well, paragraph 29 of our case says that it's important not to lose sight of the fact that the issue here is whether the crossing rules govern the encounter between our ship and the Eversmart, not simply whether they applied to the Alexandra 1. And to ask how far from or close to the channel in terms of time or distance the crossing rule ceased to apply to the Alexandra one is in a sense to miss the point, because for as long as the Ever Smart is navigating in the channel and the Alexandra one is approaching the channel with the intention of, in preparation for entering it, the crossing rules have got no relevance to their encounter. Now, we do rely here upon what the Ever Smart understood to be the Alexandra one's intentions, as found on the facts by Mr. Justice Tier. Mr. Justice Tier, in paragraph 70 of the judgment, which is page 207 of the bundle, found that it was or ought to have been obvious to that the Alexandra one was waiting to embark a pilot. We also know from the movement schedule that at C-9, the outgoing pilot warned the master of the Ever Smart that the tanker, Alexandra one, was to port and to take care. Mr. Justice Tier, having recorded that finding at paragraph 27, then went on to hold in paragraph 74, page 205, that the Ever Smart was or ought to have been aware that Alexandra one was proceeding towards the channel, intending to embark the pilot, and then proceed down the channel. There was a concession in Ever Smart's skeleton at trial, which was considered to be a sensible concession by the Court of Appeal in paragraph 60 of its judgment, acknowledging that the Ever Smart knew Alexandra one was waiting to enter the channel. And then we also have Mr. Justice Tier's finding at paragraph 111 of the judgment, page 219, that it was known to Ever Smart that Alexandra one was outside the channel, preparing to enter it, and that the vessels might meet either in the channel or in the approaches to it beyond Number 1 buoys, and that Ever Smart must have known that Alexandra one was waiting to embark a pilot. Likewise, Court of Appeal makes very similar findings. Court of Appeal paragraph 60, page 163. At all material times, Alexandra one was already in the pilot boarding area. She was there to state the obvious with a view to embarking a pilot and entering the narrow channel. That was the only reasonable inference to draw. And if you go back to the Pekin decision that we looked when I was addressing you on question 2, and you look at the reasonable inference to be drawn as to the future course of a vessel, based upon what you know about her location, what you've been told, what you observe, then these are not crossing ships, because it is known that Alexandra one is about to enter the channel. That is what displaces the crossing rule. It is the circumstance of knowing what she is doing, where she is placed, and knowing that there is no other sensible inference to draw from the fact that she is where she is at the time that she is, knowing that your pilot that's just got off your vessel is proceeding towards her. So that's what we say affects the decision as to the regime that applies. It is my learned friend's difficulty.
Well, just before you go on, if I might interject just for a minute, I'm not sure I'm getting any precise clarity as to the questions that I'm asking you, because as I understand it, what you're saying is where one, well, I don't know whether you are saying this exactly, but you're saying one ship's in the channel, and so long as they know that the other ship is intending to come into the channel, the crossing rules won't apply. Is that right?
Yes, I mean it's a vicinity test. It's certainly it's a vicinity test, and when you look at the position and the encounter of our two vessels here, with the Alexandra one being very close to the position that she would be in,
well, this
in
is
order to start.
Sorry to interrupt.
Yes.
But is it a vicinity test, or is it a realization as to what the other ship is doing test, or is it a combination of both?
It's a combination of both, and we would say that it's not dependent upon being able to observe shaping. Shaping doesn't feature in the way the test is formulated in Cullomason or in the Canberra Star. It merely refers to an encounter where one of the vessels is intending to enter the channel. And if you apply common sense to what must have been in the mind of prudent mariners on the Eversmart, knowing that the Alexandra I was waiting to board a pilot, and we have the findings made by the trial judge and the Court of Appeal which support her knowledge that we were waiting to enter the channel, waiting for the pilot, then there is no difficulty whatsoever in concluding that the relevant regime to apply is the narrow channel regime extended by the Rule 2 principle to the immediate vicinity. It's not necessary to legislate for other cases, I would respectfully submit, with facts dissimilar from the present. It may be a temptation, and of course it is, for the highest court in our land to seek to give guidance, but very often that guidance cannot be given until the particular facts arise which show what the particular considerations are that ought to inform the answer. Here we have an encounter where it was plain and obvious on the findings of fact, and as you know from the evidence you've seen, that the Alexandra I was preparing to enter the channel, and she had done everything that she needed to be in a position to pick up her pilot. The one thing she did wrong was not turn to starboard at C-4, because she overheard incorrectly a VHF conversation between port control and another vessel at an earlier time and thought that it was referring to the Eversmart. That breach of a failure to line up as she should have done in the way that the Rule 2 duty was formulated by the court does not mean that the crossing rule is the rule to apply. On the contrary, it's still the Rule 2 regime, but you find the Alexandra I didn't comply with that duty in the way she should, and therefore is found partly to blame for that. And that is what the court has done, finding her 20% to blame for the collision, for not having lined up as good seamanship would dictate in an approach to the narrow channel. It's not an answer to say, well, because she didn't line up correctly, it must be a crossing rule situation case. It isn't. And it would not foster safety to impose that additional layer of regime on the case. The answer is perfectly simple. It is by reference to Rule 9 and the extension of Rule 9 by reference to those vessels that are preparing to enter the channel that one develops a seamanship principle informed by Rule 2 that says all you need to do is to line up so that when you get to the channel, you can enter on the starboard side. That is an answer which is dictated by Rule 2. It is not an answer that is mandated by the crossing rule. You don't need the crossing rule, and indeed if you impose the crossing rule, the answer given by the elder brethren would have been completely different. It would have required her to hold back, not even attempt to approach the channel, to keep a certain distance back from buoys number 1. That question was asked of the elder brethren at the request of Mr. Turner QC at first instance, and they held that it was not necessary to keep a certain distance from the buoys, and that is because there was no priority on the Eversmart. The Eversmart was not a stand-on ship. She was not a ship for which my ship was obliged to give way.
Ms. Selvarez, I think Lord Borough's concern is that if we are to conclude that the crossing rules are to be disapplied in these particular circumstances, we should define with clarity the reasons why we come to that conclusion and the scope of the disapplication.
Well, we submit that the principle as articulated by Mr. Justice Tier and endorsed by the Court of Appeal is the correct one, and you do not need to be tempted to legislate for other cases on different facts. My submission to Mr. Justice Tier at first instance, which he recorded at paragraph 39 of the judgment, was that the crossing rule did not apply to a vessel in a narrow channel and a vessel navigating towards that channel in preparation for entering it. We submit that that is a perfectly good formulation of the principle, and which provides guidance to mariners. In the Cullum-Mason, a very similar principle was articulated. This was cited by the Court of Appeal in its decision here at paragraph 69, and is to be found at paragraph 225 of Cullum-Mason itself, where it was said that vessels approaching a narrow channel and intending to proceed along it are not bound by the crossing rule, but must enter the channel, and as they do so, keep as near to the starboard side as is safe and practicable in accordance with Rule 9. As the Court of Appeal said, it seems to me that it follows that a vessel shaping to enter the channel should, as a matter of good seamanship, navigate in such a manner that when she reaches the channel, she is on the starboard side of the channel in accordance with Rule 9. That was also cited by the Court of Appeal from paragraph 167 of Cullum-Mason. Canberra Star acknowledged that vessels approaching the channel and vessels within it have to foster continuity, and so Rule 9 would apply at the entrance to avoid chaos and ambiguity. One is talking about a principle which applies to those vessels which are navigating towards the channel in preparation for entering it. That is the scope of the application of this extension principle, to use my learned friend's terminology. And
Thank you.
That, we hope, would be sufficient to dispose of how you would decide the principle here. Lady Arden, sorry, I see that you...
If I might just go back to my question, which preceded Lord Burroughs, I was concerned about the position of other ships in the area, other vessels. They also need to decide whether or not the crossing rules apply or the narrow channel rules apply. And my concern has been elevated because you have said in answer to Lord Briggs that one of the things that must be taken into account in deciding the vicinity is the realization as to what the ship which is about to come in is actually doing. Now that gives me some considerable concern, because different ships in the area will have different understandings about the ship and its intentions. You are focusing on the Eversmart, which had additional information from the pilot and so on. But here in the dark, we have a ship which is not pointing down the channel, which is not lined up. What about the other ships in the area? Are they to take the view that the crossing rules apply or not? And if the crossing rules do apply, isn't there then an inconsistency about what they expect the Alexandra I to do and what the Alexandra I is expected to do on the judge's conclusion and that of the Court of Appeal? And I'm now talking about this as being the vicinity problem, that you're going to get people who have different understandings of what's happening with the Alexandra I. Mr. Rainey submitted yesterday, well, of course, the owners could have to contact the ship not to go down the channel. And that's just another example. How is the rest of the traffic, whose safety with which we are concerned, that Lord Wright's point in the Alcoa Rambler, how are we to say there's a safety achieved if in the vicinity Alexandra I can rely on the narrow channel rule to the exclusion of the crossing rules, but other traffic may not know that and may not be able to understand that and be seeking to expect it to apply the crossing rule?
My lady, let me tackle that head on. Obviously, an objective understanding has to be applied, but look at the terms of question 1, which are for this court, which I would urge the court not to go beyond. Question 1 is formulated in this way: on the proper construction of the collision regulations, are the crossing rules inapplicable, or should they be disapplied where an outbound vessel is navigating within a narrow channel and has a vessel on her port or starboard bow on a crossing course, approaching the narrow channel with the intention of and in preparation for entering it? Now that narrows the scope of the court's inquiry. We are dealing with vessels which are intending to and preparing for entering the channel. So one doesn't have to get into legislating for every other vessel that might be in the pilot boarding area, hoping at some future time to take on a pilot and move towards the vicinity of the approach to the narrow channel. We're only concerned here with the particular encounter between the Eversmart and the Alexandra I, and whether in terms of that encounter, where everyone knew that Alexandra I was waiting to board a pilot with a view to entering the channel, and where we have the findings of fact that Eversmart knew that, what regime applies. We don't have to be concerned about every other vessel in the pilot boarding area.
But do we not have...
Sorry, I'm sorry, Lady Arden,
it wasn't that I was saying we should go beyond the question, but surely the question of the safety of mariners in the area and vessels in the area who might be looking at the Alexandra I and deciding what it's going to do, have to be taken into account in deciding what the Alexandra I's obligations are. That's simply my point. I apologise, Lord Jones. You want to...
Not at all, not at all. I didn't mean to interrupt you. But arising out of Lady Arden's question, Ms. Salvaretna, we know that another vessel was due to cross the pilot boarding area, towing a barge.
Behind, yes, astern of the Alexandra I, yes.
Yes, but it was due to cross the, perhaps at some distance, but it was due to cross the mouth of the narrow channel. And it was
she was going to be passing a mile astern of the Alexandra I. Yes. I think that was the instruction to her from port control. We would say that there would be no risk of collision, which would attract the crossing rule, assuming that was the relevant regime.
Well, let's assume that there was a risk of collision in those circumstances. What rules would apply to the navigation of the Eversmart in those circumstances?
Well, the Eversmart would be so distant from the Zakir Bravo and her tow that it would be difficult to see what would trigger the application of the crossing rule.
Right.
But if you're...
Let's forget the particular instance and let us say that there is a hypothetical vessel crossing the pilot boarding area in such a way that there is a risk of convergence of forces so as to cause a collision. Would the Eversmart be bound by the crossing rules in those circumstances?
Well, if the objective analysis of the incoming vessel from the pilot boarding area is that she is preparing for entry to the channel.
She's crossing the pilot boarding area, not intending to enter the channel.
So it's a dissimilar factual situation from our case.
Yes.
Then it may well be that the crossing rule applies. I'm not concerned with that. All I'm concerned with is what regime applies to my ship, which is lining up to prepare for entry, and which, in the words of question 1, is approaching the narrow channel with the intention of and in preparation for entering it. Vessels which are not on that trajectory, which are not approaching with the intention of and in preparation for entering it, can be subject to rules other than Rule 9 and the extension principle. They can be subjected to the crossing principle if the orientation so aligns under Rule 15. But that is not our case, and I'm focusing...
I understand that, but that would be the application of the crossing rules in that hypothetical situation would be consistent, would it not, with the cases to which we were referred yesterday, in which the crossing rules were applied, I think in the case of the Humber and Grimsby, to vessels crossing the channel itself.
Yes. Well, you're dealing there not with a pilot boarding area situation, but with an intersection of channels type case, where you have a distinct sort of principle which is set out in the Leverington, which is not analogous to the navigation with which we're concerned. But I mean, if the court wants to refer to those other types of situations in formulating the principle, then there would be no objection to the court doing so, because it does not have an impact on the answer to question 1. My endeavour is to show that in relation to question 1 and the very narrow and focused factual inquiry that raises, which is how do you treat the regime where you have a vessel approaching the narrow channel with the intention of and in preparation for entering it? Is it subject to the crossing rule regime, or is it subject to a Rule 2 regime with a view to the Rule 9 regime then kicking in once she gets into the channel? On that particular issue, my submission is that the courts below got it absolutely right, informed by appropriate considerations of safety and seamanship, and it's materially indistinguishable from the same advice that was given by the experts in Mason to the court, and which the court accepted.
Yes, thank you. Now, Lord Briggs has been immensely patient.
I'm sorry.
No, it's the fault of the rest of us, but he does have a question for you.
May I extend my sympathy to you, Ms. Farrell, for facing this barrage of judicial questions? But it's been troubling me increasingly over the last 20 minutes along these lines. The whole underlying theory, which appears to cause us to have to identify a point at which the crossing rule ceases to apply and the narrow channel rule ceases to apply, appears in the judgments of the court below, and I think also probably at the Court of Mason, to be based on a perception. If not, then the stand-on vessel, in this case in the narrow channel, will be faced with a conflicting rule, namely the narrow channel rule, in this case to turn to starboard rather than to carry straight on. But that situation quite often affects the stand-on vessel in a situation where everybody assumes that the crossing rule applies. Suppose that the stand-on vessel has a third vessel dead ahead of her, which she is either overtaking, Rule 13 applies, or that is coming straight at her, so that Rule 14 head-on situation applies. Now, I've not heard it suggested, but tell me if I'm wrong, that that would mean that the give-way vessel says, oh, I'm no longer bound by the crossing rule, I no longer have to give way. It just means that maintain course and speed means to the extent permitted by other relevant rules, so that in the overtaking situation, the stand-on vessel would have to slow down, and in the head-on situation, she'd have to turn to starboard. Now, I don't think it's ever been suggested that the tension between the obligation to maintain your course and speed and to comply with other relevant rules, therefore disapplies the crossing rule in that sort of situation.
My answer to that would be that you always have to look at what good seamanship requires. If good seamanship would require action other than that which the crossing rule would dictate, then good seamanship trumps it. And that's how you answer how you should deal with that conflict.
So the crossing rule gives way effectively to every other consideration of good seamanship and every other rule, and is disapplied whenever there's that tension. That's your submission, I think.
Well, Rule 2 makes it plain that when you're construing any of the rules, you've got to have regard to all dangers of navigation and collision, and to any special circumstances which may make a departure from those rules necessary to avoid immediate danger. And if the strict application of the crossing rule would, in any circumstance, not promote safety and would not be consistent with seamanship advice from the nautical assessors, if one's looking at it from a court-determined rule, then yes, it would have to take a backseat to good seamanship, because that is what the collision regulations are all about. They're to promote safety and good seamanship. And if a rule does not achieve that, then it is disapplied.
Thank you.
I don't know whether that would be a convenient moment. Maybe I could just mention one point. Lady Arden had a question which she had to repeat several times yesterday, and this was in relation to whether it was possible for two ships to pass in the channel. We've done our best to remember and to consult our old documents to the extent we can as to the position. And it's correct to say that there was no local rule which either side had been able to identify or plead or rely upon, which precluded two vessels such as Eversmart and Alexandra I passing each other within the channel and there was no suggestion that there was any preclusion of two vessels passing up and down in the channel at the same time. So I hope that helps to answer the question you had yesterday.
Thank you very much.
Yes.
Thank you.
Well, if that's a convenient moment, Ms. Selvaratnam, we'll resume at 2 o'clock, please. Thank you all very much.
Thank you very much. Thank you.